Hello and welcome back to this channel. My name is Mandy Magnan. I'm an actress, writer, producer, director in Toronto, movie reviewer, pop culture, and your YouTube commentator for everything it ends with never. Well. JAMEY, HEATH, and Wayfarer has replied back to Stephanie motherfucking Jones, and we are going to get into it. There is no time to waste. So if you're ready, I'm ready. Grab your emotional support lip gloss. You are in frame with Mandy Magnan. So if y'all remember back in December, I believe it was around December 15th, Stephanie motherfucking Jones is trying to re-amend her complaint, which she filed a year ago, okay? After fact discovery, after everyone did depositions, she's trying to re-amend it. And not only that, but now add new claims as well as add a new defendant, JAMEY, HEATH. Well, Wayfarer didn't like that very much, and I'm telling you, Kevin Fritz has been busy because his reply, chef's kiss. But also, I do want to let you know that while I read through this, it's a lot about law, okay? It does get some juicy points, and it does get very interesting if you're into that, but they mostly just hit it law by law by law. And the fact that they cite from Judge Lyman's own cases multiple times, golden. I mean, absolutely amazing. So let's just see what they have to say when it comes to Stephanie motherfucking Jones trying to amend and bring JAMEY, HEATH into that, citing, you know, that he recorded this one phone call and it was illegal and da-da-da-da-da. They have refiled, and then also they've added a couple exhibits. 2 are still under seal, but one of them is new text messages, and we are going to read through those as well. If you've been following this channel, you know that I love me a good eat up when it comes to Stephanie motherfucking Jones, because we are only here today because Stephanie Jones colluded with Blake Lively for over a month before filing Van Zandt, an illegal, unethical, fake-ass lawsuit in order to obtain otherwise illegal text messages obtained from Jen Abel's cell phone when she was terminated from JonesWorks. Okay, so you know, I just like me a little clap back at the audacity of these women. Okay, the audacity. This is where it is. Defendants and non-party JAMEY, HEATH's memorandum of law in opposition to plaintiff's motion for leave to amend their complaint. She wants to amend, and they're saying, I don't think so. Not so fast. They cite so many laws and so many cases as to why this should be denied that it's a little bit laughable and comical at this point that Jones's lawyers would even try this, because they kind of get torn apart here. So let's just get through it. All right. 8 months after the April 18th, 2025 deadline set by the Rule 16 scheduling order, and 2 months after fact discovery closed, plaintiffs moved to add 2 new claims against Melissa Nathan and add JAMEY, HEATH as a new defendant to a 3rd new claim. Leave should be denied. Rule 16b-4 provides that a schedule may be modified only for good cause and with the judge's consent. Now, they didn't get a consent from the judge. I mean, they filed a letter requesting to amend and then literally just filed their amended new complaint. Then what? The language of Rule 16b-4 makes clear that the court may modify a scheduling order only if there is a showing of good cause. The primary consideration in determining whether good cause exists is whether the moving party can demonstrate diligence. Plaintiffs fail to satisfy their burden to establish good cause and diligence. This court has previously recognized that waiting 6 weeks after discovering the underlying facts before taking action demonstrates a lack of diligence. Remember, Stephanie motherfucking Jones also tried to subpoena a non-party for a bunch of documents 6 weeks after the schedule was closed, and that was shot down by Judge Lyman because there was no good cause to do it, and she did it in a back alley sort of way without even asking the judge, and he did not like that and kind of slapped her hand a little bit for it too. There can be no dispute that plaintiffs knew that facts underlying their proposed defamation and tortious interference with prospective business relations claims against Nathan from the inception of this action because those allegations were included in their December 24th, 2024 complaint. Yeah, so you waited a year? You waited a year? Plaintiffs did not seek discovery into Nathan's alleged involvement with planting a negative article about Stephanie Jones and the publication of purportedly defamatory statements on certain websites until July 16th, 2025, after the statute of limitation for defamation expired and nearly a year after the publication of the article. Plaintiffs then waited months until after they admittedly learned of the facts they claim were necessary to bring this motion. Plaintiffs' attempt to sidestep the Rule 16b diligence requirement by relying on the more lenient standard for leave to amend Rule 15a, focusing on an alleged lack of prejudice to Nathan and Heath, and that amendment is not futile. But those considerations are only relevant if the plaintiffs first establish that they were diligent, which they have not done. Even under the more lenient Rule 15 standard, amendment should not be permitted. Nathan and non-party Heath, because Jamie Heath is not a party in this case, okay? Nathan and non-party Heath would be prejudiced by the addition of these claims, which now require reopening discovery, which has closed, to redepose Jones and depose third parties. Additionally, the claims plaintiff seeks to add are legally insufficient and thus amendment is futile. First, the one-year statute of limitations for defamation has expired, and the proposed claim against Nathan does not relate back to the existing claims. Plaintiffs also failed to identify Nathan's allegedly defamatory statements and when the statements were made as required to plead defamation. Second, plaintiffs' newly contrived tortious interference with prospective business relation claims against Nathan is duplicative of the proposed defamation claim, and the allegations make it clear that any purported interference by Nathan was at least partially economically justified. Finally, plaintiffs' proposed claim against Heath for violation of Illinois' Consolidated Statute Chapter 720, the Illinois Eavesdropping Act, is deficient because 1. Plaintiffs have not met the $75,000 threshold for the subject matter jurisdiction. 2. Plaintiffs failed to adequately allege that the court's personal jurisdiction over Heath. 3. Illinois law does not apply. 4. Plaintiffs failed to plead a reasonable expectation of privacy. And 5. Plaintiffs failed to plead actual damages from the allegedly wrongful recording as required to plead a violation of the Illinois Eavesdropping Act. Hence, plaintiffs' motion for leave to amend should be denied. On December 24th, 2024, the Jones parties filed a complaint against the Wayfarer parties. The complaint alleges 8 causes of action. 1. Count 1 for breach of contract of the employment agreement between Jonesworks and Able. 2. Count 2 for tortious interference with the Able employment agreement against Nathan, Wayfarer, and Baldoni. 3. Count 3 for breach of contract of the engagement agreement between Jonesworks and Wayfarer. 4. Count 4 for tortious interference with the Wayfarer agreement against Able and Nathan. 5. Count 5 for faithless servant against Able. 6. Count 6 for breach of fiduciary duty against Able. 7. Count 7 for defamation against Able. And 8. Count 8 for defamation against defendants John Doe 1 through 10. Among other things, the complaint alleges that Nathan contrived to plant a negative story about Jones in a Business Insider article called "Who's Afraid of Stephanie Jones?" and that Nathan and non-party Jed Wallace purportedly acted in concert with Doe's 1 through 10 to publish allegedly defamatory statements on websites about plaintiffs. On December 31st, 2024, Blake Lively filed a complaint against the Wayfarer parties, Heath, and others in the action entitled Lively vs. Wayfarer Studios, LLC, for allegedly orchestrating a digital smear campaign against her in retaliation for reporting supposed misconduct on the set of the film It Ends With Us. On February 3rd, 2025, the court in this action largely adopted the case management plan and scheduling order filed in the Lively action, including an April 18th deadline for amendment on the pleadings. And that's very interesting because Blake Lively was given another chance on July 30th to refile her second amended complaint, even though the deadline was April 18th, in order to still try to convince the judge to keep Jed Wallace in her complaint, but that didn't work. But still, there was ways to go about it, and if Jones wanted to refile an amendment, she could have asked the judge way long time ago. I mean, the deadline was in April, and now she's trying in December to re-amend. Girl, please. On July 16th, 2025, the Jones party served Nathan with document requests for material relating to Nathan's redacted. As of the July 1st, 2025 deadline for the substantial completion of discovery, the Jones parties had not moved to compel or otherwise claimed that Nathan's production was inadequate. Nathan produced additional documents on August 6th, 2025, which she designated as attorney eyes only under the protective order in this action because the new documents included information about her other clients. According to the Jones parties, the August production included documents purportedly showing Nathan blank. And remember in January, so 1 year ago, the first conference that they had with Judge Lyman was about what was to be designated attorney eyes only. And it was Stephanie motherfucking Jones and her lawyers that pushed and pushed and pushed for attorney eyes only on anything to do with other clients or trade secrets or any clients other than who's in this action. So I think it's, again, the hypocrisy of it all when she was the one that really wanted to make sure that other clients' names would not be put publicly into the court filing. On September 5th, 2025, the Jones parties deposed Catherine Case, a former employee of JonesWorks and Nathan's PR, the agency group. Nathan designated Case's testimony as attorney eyes only, as the examination implicated work performed for other tag accounts that do not concern this matter. The Jones party claims that Case's testimony evidences Nathan's involvement with the websites. The Jones party subsequently moved to have this attorney eyes only designation removed, and the court ordered the testimony de-designated over Nathan's opposition on September 19th. The Jones party deposed Nathan on September 30th and Wallace on October 10th. Each denied having any personal involvement with this website. In a November 26, 2025 memorandum and order, this court denied the Jones party's motion to compel Case to produce further materials relating to the websites in a response to a subpoena dated October 17th. The Jones parties argued that they sought materials in response to information obtained from the deposition of Case, Nathan, and Wallace. However, the court held that the Jones parties should have issued the subpoena as soon as possible after Case's September 5th deposition, and the decision to wait an additional 6 weeks before doing so demonstrates a lack of diligence. In response to the Jones party's contention that there would be no prejudice because there was not yet a deadline for summary judgment motions, the court noted that that does not mean that the parties are free to continue to issue pretrial fact subpoenas up to the moment of summary judgment. The absence of prejudice alone is insufficient to show the presence of good cause. On October 5th, 2025, prior to his deposition in the Lively action, Heath produced a recording of an August 8th, 2024 telephone conversation with Jones, who was in London. At the time the call was made, JonesWorks was still representing Wayfarer in connection with the public relations crisis developing around the film and in connection with matters unrelated to the Lively fiasco. During his deposition, Heath explained that he recorded his call with Jones because of increasing concerns over Jones's conduct. I love that they call it a fiasco, the Lively fiasco, instead of the Lively case, but that's just a little petty and I love it. On December 8th, 2025, the Jones parties moved for leave to amend their complaint to add claims for 1, defamation against Nathan regarding redacted, but that's obviously the smear websites against her, Twitter, there's Reddit, all of that stuff, Facebook. And 2, tortious interference with prospective business relations against Nathan arising from redacted. And 3, violation of the Illinois Eavesdropping Act against Heath for his recording of the phone call with Jones. Plaintiffs are not entitled to leave to amend. Plaintiffs have not shown the diligence required by Rule 16. Plaintiffs' motion for leave to amend the complaint should be denied due to their lack of diligence necessary to show good cause to amend, pursuant to Rule 16 of the Federal Rules of Civil Procedure. Especially egregious is plaintiffs' attempt to add claims for defamation and tortious interference with prospective business relations against Nathan arising from redacted, because plaintiff's current complaint filed on December 24th, 2024 already contains allegations about Nathan's purported involvements therein. Thus, the Jones parties knew or should have known about the facts necessary to bring these claims not just months prior to the April 18th, 2025 amendment deadline, but at the inception of the case. Meaning, she was already saying Melissa Nathan was part of this whole thing and da-da-da-da-da, so it should have already been known, okay? This crazy. It should have been at the inception of the case. This alone is grounds to deny the motion to amend to add these claims. Then they quote from Oscar versus BMW. A party fails to show good cause when the proposed amendment rests on information that the party knew or should have known in advance of the deadline. Rule 16 governs motion for leave to amend after a scheduling order has been entered, and thus Rule 16 governs plaintiff's motion. Rule 16b provides that a scheduling order must limit the time to amend the pleadings, and that a schedule may be modified only for good cause and with the judge's consent. With the judge's consent, which he didn't give. They just asked for it and then put it in, okay? The Second Circuit is clear that Rule 16 provides that when a deadline in the scheduling order cannot reasonably be met, despite the diligence of the party, where the moving party has demonstrated good cause, the court may grant leave to amend the scheduling order to extend the deadline. And noting, consistent with several circuits, that Rule 16b governs motions to amend after the scheduling order deadline. Rule 16b is well established as a heightened standard because Rule 16 is designed to offer a measure of certainty in pretrial proceedings, ensuring that at some point both the parties and the pleadings will be fixed. The Second Circuit is clear that Rule 16's standards may not be short-circuited by an appeal to those of Rule 15, as Rule 16 requires a different analysis, an analysis of good cause. If we considered only Rule 15a without regard to Rule 16b, we would render scheduling orders meaningless and effectively would lead Rule 16b and its good cause requirement out of federal rules of civil procedure. Then they quote from a whole bunch of cases, and one of them is cited, denying motion to amend complaint to add a new class representative 4 months beyond the scheduling order deadline after adequacy concerns raised. So that was even a case that only 4 months they wanted, and he was like, no, and now she's trying to do it. It was like more than 6 months later. The primary consideration in the Rule 16 good cause inquiry is the motives diligent. If the party was not diligent, the inquiry should end. And that's from Mr. Judge Lyman himself in a case that he did. It's literally a quote from his case that says the primary consideration in the Rule 16 good cause inquiry is the motives diligent. If the party was not diligent, the inquiry should end. Courts routinely deny leave to amend after a scheduling order deadline where the movant fails to show diligence and in discovering the facts or in seeking amendment. The absence or presence of prejudice cannot be used to sidestep the Rule 16b diligence requirement. For motions to amend governed by Rule 16b, although the existence of degree of prejudice to the party opposing the modification might supply additional reasons to deny a motion, the focus of the inquiry is upon the moving party's reasons for seeking modification. refusing to find good cause under Rule 16A, where the party received notice long in advance of the deadline that the complaint did not name all necessary parties. In other words, a district court may consider other relevant factors outside from diligence, including whether the amendment of the pleadings will prejudice the defendant, but the absence of prejudice to a non-moving party does not alone fulfill the good cause requirement of 16B. The moving party must first show diligence. Despite clear guidelines from the Second Circuit, plaintiffs incorrectly argue that the standard of Rule 15 applies for plaintiffs' untimely amendment. It does not. However, even if plaintiffs had timely filed their motion to amend the complaint 9 months ago, and within the parameters of this court's scheduling order, which they did not, plaintiffs still failed to satisfy the more lenient Rule 15 standard. Under Rule 15, motions to amend should generally be denied in instances of futility, undue delay, bad faith, or dilatory motive, repeated failures to cure deficiencies by amendments previously allowed, or undue prejudice to the non-moving party. Moreover, according to the proposed amended complaint, Nathan's alleged involvement in the publication of false statements on the websites occurred in May of 2024, and the Business Insider article was published August 15th of 2024. Yet the Jones parties did not serve discovery requests seeking redacted until July 16th of 2025. After the statute of limitations had run on any defamation claim relating to the websites, and nearly a year after the publication of the Business Insider article. Damn. So they're saying it was already, the time had run out. The statute of limitation has already run out. She only asked and subpoenaed Melissa Nathan July of 2025. The article ran May of 2024. So even that was already too late, babes. It's already too late. The Jones party's lengthy and unexplained delay. The Jones party's lengthy and unexplained delay in seeking discovery regarding these issues, which underlie their proposed claims against Nathan in the current motion for leave to amend the complaint, further demonstrates their lack of diligence. Plaintiffs concede that they knew about Nathan's alleged involvement with the Business Insider article at least as early as August 6th, 2025, when Nathan produced documents relating to this allegation. Yet, plaintiff did not move for leave to amend until December 8th, 2025, over 4 months after they purportedly learned of this fact. As this court held in the case MTC order, a 6-week delay demonstrates a lack of diligence. Here, plaintiff's delay lasted over twice as long and is therefore even stronger evidence of their lack of diligence. And let's also remember as well that in the Lively versus Wayfarer, when Wayfarer tried to even subpoena or even ask to have Taylor Swift subpoenaed, only 10 days after the close of subpoenas, the judge was like, no, it's not anyone else's fault that you didn't do it on time, right? Like you should have had this planned way back playback. So now it's kind of like, same thing here. I feel like, how is 6 months later you're going to try to amend it, or 9 months later you're going to try to amend something after fact discovery? I mean, it should have been done in April, and in the latest, after Jed Wallace was deposed on October 10th, they had now from October 10th all the way until December, right? Lots of time to ask the judge, lots of time, and they didn't do that. Similarly, plaintiffs concede that they knew about the recording of the phone call that forms the basis of their proposed Illinois Eavesdropping Act claim against Heath as of October 5th, 2025. Yet they waited over 2 months to bring this motion. Again, longer than the 6 weeks this court held evidenced a lack of diligence. Plaintiffs' long-standing pattern of lack of diligence eviscerates any argument that they have to show good cause pursuant to Federal Rule Civil Procedure 16, and thus their motion for leave to amend should be denied, and the court should end its inquiry there. In the footnote, this is a good footnote. Unrelated noted, the initial case management plan and scheduling order was filed by the court on February 3rd. Lively, Jones, and JonesWorks moved to amend the scheduling order to extend various discovery dates and the date for motions to compel. Jones and JonesWorks did not seek to amend the deadline for the amending the complaint. On July 15, 2025, the court amended the scheduling order, but did not amend the deadline for parties to seek leave to amend their complaint. On October 6, 2025, the scheduling order was amended with respect to expert disclosures and discovery. Again, no amendment was requested or ordered with respect to the deadline for amending the pleadings. So there was a lot of time here that Jones and Blake Lively kept asking for extensions. I mean, we've seen it for over a year now. They kept the scheduling order changed, and it was extended, and never once did JonesWorks ask to amend the case when it comes to amending her pleadings. Plaintiffs are not entitled to leave to amend under Rule 15. Nathan and Heath would be prejudiced by the late amendments. Although Rule 15 provides that leave should be freely given when justice so requires, amendment should be denied for undue delay, bad faith, or dilatory motive on the part of the movant, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party, or futility of amendment. And that's from the case that's McCarthy versus Dunn and Bradstreet Corporation. And then another quote from Judge Lyman that says, undue delay, bad faith, and dilatory motive weigh against amendment, from Judge Lyman. Okay? The failure to show diligence under Rule 16 should weigh heavily against, if not forecloses, amendment under the more liberal requirements set forth under Rule 15A2. While a lack of diligence and undue delay are factors, prejudice is considered the most important factor in a Rule 15 determination. Prejudice exists where amendment would require significant additional discovery, cause substantial delay, or alter the litigation's nature on the eve of dispositive motions or trial. Allowing plaintiffs' proposed amendment would necessitate yet another extension of the discovery deadlines, in this case to allow the parties sufficient time to conduct discovery, causing undue delay to the resolution of this case. It is clear that if leave to amend were to be granted, defendants would be prejudiced because discovery is closed. This is true, whereas here a motion to amend seeks to add an entirely new defendant, being JAMEY Heath. Plaintiff's amendment would require significant additional discovery, further delaying resolution of this action. For instance, plaintiffs initially asserted a defamation claim against John Doe's. A defamation claim against Nathan would require a new discovery on, among other things, whether any of the alleged defamatory statements were true or otherwise privileged, to whom the statements were made, when the statements were made, and plaintiffs' purported damages flowing from each allegedly defamatory statement. At the very least, A, Jones and JonesWorks deposition would have to be reopened. B, additional written discovery would have to be propounded upon the parties. C, subpoenas would have to be served upon non-parties, including current and former employees of JonesWorks, as well as current and former clients of JonesWorks. And D, those non-parties would have to be deposed. The proposed tortious interference with prospective business relation claims against Nathan would also require substantial discovery to determine the non-speculative business opportunities that would have been available to plaintiffs and the concrete profits that those claimed future opportunities would have generated. While discovery was conducted on plaintiffs' existing claims for interference with existing contracts, discovery on potential future relationships would open a whole new ballpark of fact discovery on subjects which are irrelevant to the existing claims and thus had not been delved into by any party. For instance, with respect to the Business Insider article, Jones and Jones Works would have to be redeposed. Subpoenas for documents would have to be issued to Business Insider, as well as to all sources of information used in the article. Example, the people with whom the author spoke. And the authors of anyone who provided information for the article would need to be deposed. Expert discovery would also be implicated on the reasonableness of claimed losses from the future business relationships. Finally, Heath is a new party to this lawsuit. Heath would be entitled to discovery relevant to the eavesdropping claim and his defenses. For instance, under Illinois law, plaintiffs must prove actual damages from the alleged recording. Thus, crucial discovery, including plaintiff's deposition, would be required to establish whether plaintiffs were damaged by a single recorded call between Heath and Wayfarer's public relation agent, Jones, and the amount of such damages claimed, if any. Heath may also seek non-party discovery from Jones's family members who were in London with Jones and may have been present during the call, destroying any reasonable expectation of privacy, an essential element of an Illinois eavesdropping claim. In sum, the extensive additional discovery that would be required by the amendments long after fact discovery is closed, long after, would significantly and unduly prejudice defendants and delay trial. The proposed amendments are futile. In assessing futility of amendment, courts apply the same standard as Rule 12b-6 motions to dismiss. Thus, an amendment is futile if it would not survive a motion to dismiss. Where claims are time-barred or legally deficient as a matter of law, amendment is futile. The proposed defamation claim is time-barred. New York law provides a 1-year statute of limitation for defamation claims. Thus, if the proposed claim for defamation against Nathan does not relate back to the complaint, the claim is untimely. Section 1024 allows for a DOE substitution on a related party theory after expiration of the statute of limitations party where a plaintiff 1. Exercised due diligence prior to the running of the statute of limitations to identify the defendant by name, and 2. Describe the John Doe party in such form as will fairly apprise the party that he is the intended defendant. John Doe pleadings cannot be used to circumvent statutes of limitations. Plaintiffs failed to make a diligent effort to identify Nathan as the unknown defendant prior to the commencement of this action. Plaintiffs failed to make a diligent effort to identify Nathan as the unknown defendant prior to the commencement of this action through the date the statute of limitations expired. There is no evidence that plaintiffs exercised any pre-action due diligence to ascertain the identity of the John Doe defendants. The alleged defamatory websites were published in May of 2024. Plaintiffs waited more than 7 months until December 24th, 2024 to commence this action. Plaintiffs then waited another 7 months until July 16th, 2025 to serve Nathan with requests for documents pertaining to the redacted. Those requests were served after the statute of limitations expired. And the redactions, I think, have to do, obviously, with the Stephanie Jones leaks, etc., etc. Those requests, though, were served after the statute of limitation expired in May of 2025. And then they cite, again, a whole bunch of cases like that. And one of the examples is pretty good. It says, plaintiff failed to establish that he made timely and diligent efforts to discover defendant's identity prior to when the statute of limitations expired. If the Stephanie Jones leaks and who's afraid of the big bad Stephanie Jones and all that was so important and such a detriment to Stephanie motherfucking Jones and Jones Works, why did she wait all of that time to even file against it? Why wasn't she already looking into it? Why wasn't she already filing a lawsuit with John Doe's 1 through 10, etc., and filing subpoenas and doing all of that? This is just such a weird game that they're playing. According to their complaint filed a year ago, plaintiffs believed that John Doe defendants acted in concert with Nathan to publish the websites. In other words, plaintiffs knew of Nathan's identity and purported involvement with the websites when they filed their complaint in December of 2024, but nevertheless waited until the statute of limitations expired to assert a defamation claim against her. Plaintiffs have not exercised the due diligence necessary to invoke the relation back doctrine, and amendment to add a defamation claim is futile. Plaintiffs fail to plead the elements of defamation. To plead a defamation claim, a plaintiff must adequately allege 1. A written defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. 3. Fault, either negligence or actual malice. And 4. Falsify of the defamatory statement. And 5. Special damages or per se actionability. The complaint must identify the purported communication and an indication of who made the communication, when it was made, and to whom it was communicated. And in the footnote here, it does say, although plaintiffs allege they also serve subpoenas on the platforms hosting the websites and social media pages, they neglected to attach those subpoenas to their motion, likely because they too were not served in a diligent fashion. Just like when she filed her complaint and her counter complaint and tried to oppose Wayfarer's lawsuits, and they kept saying, oh, we got the Jen Abel text through lawful subpoenas, but they never actually attached the subpoenas because now we know that it was the Van Zandt subpoena. Girl, get out of here. First, plaintiffs do not attribute a particular statement to Nathan. Rather, Nathan allegedly made a published defamatory statements to at least one other person, and in some cases to multiple persons. Wallace and Nathan published the false and defamatory website about Jones and Jones Works. On information and belief, Nathan, Wallace, Kalantari, Skyline, and the defendants published the defamatory statements on the websites. John Doe's 1 through 10 and Nathan published or caused to be published the websites. Such group pleadings is insufficient to meet the exacting standard for identifying the maker of each communication. Then they cite from Luthen versus Seagram, which dismissed defamation claim where plaintiff did not specify which defendants made the statements. In addition, with a single exception, plaintiffs have failed to identify the temporal aspect of the statements with the requisite specificity. The proposed amended complaint identifies only one date when a single alleged defamatory statement was made, but no others. Thus, the temporal aspect of the defamation claim is insufficiently pled, and the claim is deficient. The proposed tortious interference claim is deficient, and it's also duplicative. The Second Circuit held that a tortious interference claim must be dismissed as duplicative, where it is premised on identical underlying factual content as a defamation claim, where the alleged harm derives from the purported defamatory statements rather than an independent source. The tortious interference claim cannot survive as a separate cause of action because claims sounding in tort are in fact defamation claims, where the entire injury complained of by plaintiff flows from the effect on his reputation. Plaintiff's proposed claim for tortious interference with prospective business relations is duplicative of the defamation claim. Both claims arise from Nathan's purported publishing of false statements on the websites. Most importantly, the alleged harm to plaintiffs from both claims arises out of the purported effect of plaintiff's reputation. Because the tortious interference claim against Nathan is duplicative of the defamation claim, amendment to add the tortious interference claim is futile and leave to amend should be denied. The tortious interference claim is not pled with specificity. Specificity. Oh my gosh. The tortious interference claim is not pled with specificity. To state a claim for tortious interference with business relations under New York law, a plaintiff must adequately allege that 1. The plaintiff had business relations with a third party. 2. The defendant interfered with those business relations. 3. The defendant acted for a wrongful purpose or used dishonest, unfair, and improper means. And 4. The defendant's acts injured the relationship. And then again, quoting Judge Lyman, this quote, first, at the motion to dismiss stage, a plaintiff must specify some particular existing business relationship through which plaintiff would have done business, but for alleged tortious behavior. from Judge Lyman. And that's quoted from Judge Lyman on a Brown Media Corp versus K&L Gates, as well as Cambridge Capital LLC versus Ruby Has. And it quotes again, dismissing tortious interference with prospective business relations counterclaim where defendants have not identified any specific business relationship with which plaintiffs interfered. And that's from another case that he was also working on. I think it's brilliant that 3 or 4 times now they've quoted Judge Lyman's past cases. You feel me? Dismissing counterclaims that, as pled, did not contain sufficient factual material to make out a claim for tortious interference with prospective economic advantage. Plaintiffs failed to specify any business relationship with which Nathan purportedly interfered, referring to only a single unidentified mutual client, which is insufficient to plead a tortious interference claim. Next, for wrongful means, a plaintiff must demonstrate that the defendant's conduct amounted to a crime or an independent tort. Plaintiff's allegations are woefully short of meeting this standard. Plaintiffs allege that Nathan engaged in a public relations campaign to plant negative and false stories in the press and on the internet about plaintiffs. This conduct does not amount to a crime or independent tort. And that's where it's done. It's a wrap, okay? Even if, let's say, Melissa Nathan did plant the Business Insider story, it does not amount to a crime or an independent tort, right? And first, you got to prove that what she said was a lie. So let's go there, Stephanie motherfucking Jones, okay? Because I don't know. I don't think they were lies. Pleading the presence of false statements alone is not enough to support a claim for tortious interference. No reasonable juror could conclude that plaintiffs satisfy the elements of tortious interference with prospective economic relations merely by showing that defendants said bad things about them. Here we go. Right. Oh my gosh, he said really mean and bad things about me on the internet. Okay, but and okay. Finally, conduct constituting tortious interference with business relations is by definition conduct directed not at the plaintiff itself, but at the party with which the plaintiff has or seeks to have a relationship. Thus, allegations that are directed at the plaintiff rather than a third party could not satisfy the wrongful means elements even if they did sufficiently allege tortious conduct. Here, plaintiffs' allegation of misconduct are entirely directed at plaintiffs themselves. Nathan is alleged to have carried out a negative publicity campaign directed at plaintiffs. There are no allegations of any conduct by Nathan toward any third parties, including the unidentified mutual client. Therefore, plaintiffs have failed to adequately plead a claim for tortious interference with prospective business relations. This claim is insufficient and the request to add it should be denied. The alleged tortious interference is economically justified. A well-recognized defense to a claim for tortious interference with prospective business relations is that the conduct at issue was taken to protect a party's economic interest. When a defendant has acted with a permissible purpose, such as normal economic self-interest, wrongful means have not been shown, even if the defendant was indifferent to the plaintiff's fate. For instance, the court dismissed tortious interference with prospective business relation claims where the defendant's actions were motivated by legitimate competitive interest rather than wrongful purposes. Plaintiff's proposed tortious interference claim fails because it alleges that the conduct at issue was undertaken by Nathan, at least partly for a legitimate competitive purpose rather than a wrongful one. Plaintiffs allege that Nathan's negative public relations campaign was done intending for a mutual client to terminate his relationship with Jones and Jones Works, and that the mutual client ultimately and as a result did not renew or enter into a new agreement with Jones and Jones Works that he would have but for the aforementioned conduct. Indeed, plaintiffs expressly allege that Nathan's motivation was for Nathan to maintain that client. By plaintiff's own allegations, therefore, the alleged conduct was undertaken for a competitive purpose and to protect Nathan's relationship with this purported mutual client. For this additional reason, The claim for tortious interference with prospective business relations is insufficient, and the motion to amend to add this claim should be denied. The proposed eavesdropping claim is deficient as well. Let's just go there. We're moving on to JAMEY Heath, okay? She's trying to bring JAMEY Heath into this, stating, oh, he recorded me and falsely recorded me. Get out of here, okay? Be a grown-ass woman right now. You have bigger fish to fry, okay? Subject matter jurisdiction requires plaintiffs must plead damages that exceed $75,000 exclusive of interest and cost. This amount in controversy threshold cannot be aggregated among various defendants. It must be satisfied with respect to each defendant. Conclusory allegations that the amount in controversy requirement is satisfied are insufficient. Plaintiff's proposed claim for violation of the Illinois Eavesdropping Act fails to establish that a reasonable probability that Heath's recording of a single phone call would or did cause plaintiff in excess of $75,000 in damage. In fact, plaintiffs do not claim any damages specifically in connection with the proposed cause of action. Rather, plaintiffs merely allege in conclusory fashion that all their claims in the aggregate exceed $75,000. That is insufficient because the law is clear that plaintiffs must satisfy the jurisdictional amount as against each individual defendant. Moreover, plaintiffs do not allege facts sufficient to make damages exceeding $75,000 reasonably probable as is required. Plaintiffs do not allege, for instance, that Heath published, disseminated, or otherwise used the recording in any improper way that would have caused them damage. Granting summary judgment dismissing Illinois Eavesdropping Act counterclaim for lack of damages where recordings were not published or disseminated in any way. And that is a direct quote from MediaLogic USA versus Pre-Nova US. Accordingly, plaintiffs failed to plead to a legal certainty that this claim would support damages in excess of $75,000. Right, how was him recording a phone call that he never used, never told nobody about, didn't do nothing with it, never even put it out to the public, did nothing with it? How did that cause you damage, girl? It didn't. You are just pissed off and seeking revenge, and you're bitter once again, okay? You're bitter because he caught you, and you didn't know. That's it. Plaintiff's proposed amendment complaint fails to allege personal jurisdiction over Heath under either New York's long-arm statute or the Due Process Clause. The plaintiff bears the burden of establishing that the court has jurisdiction over the defendant. The proposed amended complaint does not allege that Heath is domiciled, physically present, or personally does business in New York as required to support an exercise of general jurisdiction under CPLR Section 301. Plaintiff's Illinois Eavesdropping Act claim does not arise out of activities that Heath purposely directed at New York. The alleged conduct on which plaintiff's claim is based did not take place in New York. Heath placed the call from Illinois to Jones in London. While Jones Works has its principal place of business in New York, personal jurisdiction turns on a defendant's contacts with the forum state, not a defendant's contacts with the plaintiff who resides in that forum. The proper question is not where the plaintiff experienced a particular injury or effect, but whether the defendant's conduct connects him to the forum in a meaningful way. Plaintiffs argue that Heath is already a named defendant in the Lively matter, but it is well established that participating in other litigation cannot establish specific jurisdiction, which must be based on contacts with the forum related to the claim at issue. Involvement in other cases in New York does not create specific jurisdiction because a defendant's relationship with a third party, standing alone, is an insufficient basis for jurisdiction, and those other cases create no connection between the forum and the specific claims at issue here. The Illinois Eavesdropping Act does not apply. Even if this court had jurisdiction over the claims against Heath, the Illinois Eavesdropping Act does not apply. The only hook for plaintiff's proposed claim under the Illinois Eavesdropping Act was Heath's temporary presence in Illinois when the call in question was made. However, neither plaintiffs nor Heath are domiciled in Illinois, and neither are alleged to have any interest in or connection with Illinois. Applying Illinois Eavesdropping Act to scenario where a party in New York reached into Illinois to record a call with a party in Illinois and injury was sustained in Illinois, because there is no basis to apply the Illinois Eavesdropping Act here, adding the proposed claim is futile. Plaintiffs lack standing to bring a statutory claim under Illinois law. Indeed, courts routinely hold that a plaintiff is unable to pursue claims based on statutory causes of action created by states where plaintiffs neither lived nor were injured. Given that the purpose of the Illinois law is to assure Illinois citizens that their conversations would not be recorded by another person without their consent, there is no basis to apply the law to a claim brought by plaintiffs who are not alleged to have suffered any injury in Illinois. Given that the court lacks subject matter jurisdiction over the proposed claim against Heath and lacks personal jurisdiction over him, and given that the Illinois Eavesdropping Act is inapplicable, the court need not decide whether the laws of the United Kingdom, where Jones was located at the time of the call, New York, where Jones Works maintains its principal place of business, or some other jurisdiction applies to any claim by plaintiffs for eavesdropping, and whether under that law plaintiffs can state a claim. For example, New York law permits conversations to be recorded with the consent of only one party. And that's where Miss Jones and Jones Works is, in New York. And guess what, babes? New York is a only one party consent recording place, okay? Plaintiffs do not establish a reasonable expectation of privacy, and this is the part that I found the juiciest, and this is pretty much the end of it, but I really liked what they were saying. Assuming the Illinois Eavesdropping Act applies, the statute only applies where there is an expectation of privacy. It defines a conversation under this statute as any oral communication between two or more persons, whether in person or transmitted between the parties by wire or other means, when one or more of the parties intended the communication to be of a private nature under circumstances reasonably justifying that expectation. Where there is no expectation of privacy, a claim under the Illinois Eavesdropping Act fails. And guess what? She was not in a private space, y'all. Plaintiffs do not plead a reasonable expectation of privacy because, one, at the time of the call, Jones was with other individuals who could overhear her. And two, both parties contemplated sharing and in fact did share the content of the call with others. Thus, the Illinois Eavesdropping Act claim is legally insufficient and the motion to amend to add this claim should be denied. As Jones noted in Contemporaneous Communications, she was in London with her family at the time of the call was made. On the call itself, Jones stated, "My entire family is here," and they have timestamps, okay, for each of these little statements made by Jones. On the call, Jones can be heard speaking with someone else. And at various moments of the call, between 1:35 and 1:50, 10:23 and 10:47, 11:47 and 12:34 to 12:35, other voices on Jones's side of the call, presumably her family members, can be heard. Accordingly, Jones did not have a reasonable expectation of privacy on the call. The proposed Illinois Eavesdropping Act claim fails. Further, the purpose of the call between Jones and Heath was to discuss Jones Works' role as representative of the Wayfarer parties under the Wayfarer agreement, whether plaintiffs were reasonable for a leak to the Daily Mail, and whether or not plaintiffs should continue to speak publicly on behalf of the Wayfarer parties. At various times on the call, Jones indicated her intention to communicate the content of the call with third parties. And it's quoted here some shit that she said to Jamie Heath on this call, which is, "I can call anyone and speak about something they said about Stephanie Jones. I will call Leslie, Blake Lively's PR consultant, and tell her that I heard she said I was leaking things to the Daily Mail, and I want her to know that I haven't. You cannot take my name and my livelihood and my integrity and say that Sony is accusing me and then try to prohibit me from calling Sony. I am going to let Danny, a Sony representative, know that I did not call Daily Mail. I can let anybody that I want to know that I did not call." She just sounds like such an entitled brat. Like, what a horrible person to do business with. She in my opinion, is just like Blake Lively when Justin Baldoni said, she's a woman who always thinks she's right. Your client who's paying you over $30,000 a month is telling you not to do anything else, to stand down, not to say shit. And your behavior is this: I can do anything I want. I'm Stephanie Jones. You're not going to take my livelihood and my integrity. Shut up, bitch. Like, shut up. True to her word. Okay, when she said all of that shit above there, I can do whatever I want. Well, true to her word, Jones did, in fact, discuss the content of the call extensively with other parties besides Heath. The same day as the call. The same day as the call. For example, she engaged in an extensive texting thread with not only JAMEY Heath, but also Jennifer Abel and Tara Hanks, the latter a representative of the Wayfarer parties, that covered who was responsible for the Daily Mail leak, as well as whether plaintiffs could respond to media inquiries on behalf of the Wayfarer parties. The next day, on August 9th, 2024, Jones redacted. And maybe that's a call to Leslie Sloan. Maybe that's, I don't know what that is, but we're going to find out. We're going to find out one day, I hope. And on August 14th, 2024, she had threatened to do Jones another redacted, but she's threatened somebody. And I want to know who. But those two exhibits are still under seal, my friends. Those two exhibits still under seal. Because Jones shared the content of the call with others beside Heath, she can have had no reasonable expectation of privacy regarding the call. Period. Done. The fact that, like, what are these lawyers thinking? What are these lawyers thinking? Trying to put this stuff in there when it's like clear that it's against the law. Like, the law doesn't even agree with you. Like, there's not even a chance. Like, this is crazy. Because Jones shared the content of the call with others besides Heath, she can have had no reasonable expectation of privacy regarding the call. Thus, the proposed Illinois Eavesdropping Act is deficient, and the motion to amend to add it should be denied. Plaintiffs failed to plead any actual damages. Civil remedies for violations of the Illinois Eavesdropping Act are 1. Injunctive relief, 2. Actual damages, and 3. Punitive damages. As noted, plaintiffs failed to plead an actual damages, rendering the claim legally insufficient. Notably, even if the plaintiffs sought punitive damages, such as damages are warranted only in cases where an individual acts with malice, deliberate violence, or gross negligence, indicating a wanton disregard for the rights of others, none of which is pleaded or evident from the allegations of this claim. For the foregoing reasons, plaintiff's motion should be denied in its entirety. Thank you so much. And that is from the one, the only Kevin Fritz, with our zaddy of it all, Brian Freeman, and then also signed by Alexandra Shapiro. Thank you so much, ladies and gentlemen. It just blows my mind, like, when you read the reply like that they are just running Wayfarer through the ringer. They are making them fight these motions that are just so dumb. Like, dumb. Like, how do you get your lawyers to draw something like that up, Stephanie motherfucking Jones, when you knew damn well your lawyers should have at least looked into this law and known better? They're just trying to exhaust the Wayfarer people at this point, in my opinion, and make them spend time on shit like this instead of what's actually important. Y'all better figure out where your evidence is, okay? Because 9 months later, you want to try to amend your complaint? But what we did get, out of the 3 exhibits, we got 1 unsealed, and it is a text chain. Let's go. And I'm going to be real honest here. I haven't read this yet, so let's see what it is. Exhibit 2. This looks like the message that they all got from the Daily Mail. This is a text thread by Stephanie Jones, Tara Hanks, JAMEY Heath, and I'm sure Jennifer Abel is going to be in this because that's what they said in their complaint, but maybe not. So this is the thing that they got. It's a call for comment, right? People on social media are talking about how they don't pose together and all of that at the premiere, do any press together. I wanted to give you a chance to respond to these rumors. Please let me know if you have any comments. Thank you. I mean, really, just because it's coming from influencers and internet sleuths and social media people doesn't mean it's true. Like, anything can be made up. I mean, look at what just happened with Stranger Things, Conformity Gate. I was on it. I was like, it's definitely happening January 7th. I mean, there's so much stuff that just like pops off because of like social media people, and you could just deny. But anyway, we're long gone past that stage. Stephanie Jones says, Jen, so Jen is on the call. That's what I thought. Okay. So it says, Jen, just tried you. Please give me ring. Thanks. One thing about Stephanie motherfucking Jones and Leslie Sloan, their texts are messy. These girls must be busy because they can't text worth shit. I'll tell you that. Leslie Sloan, her texting awful. There's so many mistakes. Anyway, she writes, Jen, just tried you. Please give me ring. Thanks. Lillian has been nice and fixed things for us in the past. I can give her that. This is a nothing burger. Hi, we're going through security and checking luggage. Melissa and her team are into this already. I believe that's from a reply from JAMEY Heath. Stephanie Jones liked that and says, all good, I'll call. Then JAMEY Heath says, hold on. Or I guess that would be from Tara. It's from somebody, but it's redacted, which is strange because their name I guess there's a bunch of people redacted. And I digress. Somebody said that. Then JAMEY Heath says, hold on, guys. Please, no one call Daily Mail right now. Melissa's in the middle of it. I want to be sure we are all aligned. Oh, sent email that I left word and playing phone tag with her. It was my understanding Melissa was strategy, not dealing with media comms. So already just from this, I can tell that Stephanie motherfucking Jones was so jealous that they brought Melissa Nathan on, just like Alex Sachs was so pissed off and jealous that they hired JAMEY Heath as the producer for set, right? Because it's like, oh, I was under the understanding that she wasn't going to do that. It's like, fuck off, you know? Hold on, everyone. I'm very confused. Why would anyone call anyone without consulting with everyone first? This is not good. No one is to do anything at all without my knowledge first. This could really blow things up. I acknowledged receipt to Lillian and said I'd contact her. We always do, which is part of our job. No one should be contacting media except JonesWorks, as we are agency of record. Unsure how Melissa is in the middle of it. We were not privy to those discussions with Melissa, although we should be. Jealousy. JAMEY Heath replies, I am hearing from Sony that, quote, somebody named Stephanie Jones has responded out to Daily Mail saying that Blake is to blame, and now this has escalated it all. We were purposely not responding to anything as to not fuel. This has fueled it. Everyone stand down unless I am aware of any moves. I don't care who is supposed to do what. I'm most interested in that. I'm interested only in any strategy being run by me. I need all to understand that. Stephanie Jones, I didn't even speak to Daily Mail, so I know this isn't true. Please tell me who at Sony said this, as I don't believe it for 1 minute. Who at Sony? And we all know that I would never say Blake is to blame. I'll contact Sony Comms now, as I know this isn't true. I mean, crash out queen, holy moly. And if you look at even the timestamps, it's like at 12:20 she said it. Then at 12:21, a full minute later, no one replied, so then she writes it back. And then 2 minutes after that, she replies back like, woo, hold the phone. JAMEY Heath, do not contact anyone at all right now. Contact. I'm sorry for being direct, but I need it to be direct. So I don't want any messaging with anyone else right now. So I am officially needing that to be understood. Jones, to clarify again, I have not spoken to Daily Mail. The above isn't true. I also don't believe Danny or Kim at Sony are saying that above. Quote, also has spaces as if it was just being drafted. I am not contacting press, but it is concerning if Danny or Kim are saying that I've escalated this, as I haven't touched this. I am going to contact them. Edited. I am not contacting press, but it is concerning if Danny or Kim are saying I have escalated this, as I haven't even touched this. I am going to contact them. JAMEY, Stephanie, as your client and the one that pays for your services, I am stating to not contact anyone regarding Wayfarer or Sony at this time. If you do after this text, it will be a major problem. This needs to be respected now. That right there proves that them firing JonesWorks and ending their contract with them and going with Jen Abel was the right thing to do, because she's not listening to their wishes. Who would ever want someone representing them that isn't listening to them? Ew, never. Then she replies, Steph Jones, JAMEY, I have not spoken to Daily Mail. I have not spoken to Danny or Kim at Sony. The above is a significant accusation, and I find it hard to believe true. My main goal is and always has been to protect Justin. What? That's your goal, ho? Because Van Zandt? Oh, come on. Okay. I was not aware Melissa was in the middle of it, as I was told she was only helping with scenario planning. The email came to us and I promptly forwarded it to you, Tara, and the team. Then she edits that text to say, please give me a call when you land so we can discuss and align on the plan. Then she edits again. Jamie, I have not spoken to Daily Mail. I have not spoken to Danny or Kim at Sony. The above is a significant accusation. I find it hard to believe true. My main goal is and has always been to protect Justin. I was not aware Melissa was in the middle of it, as I was told she was only helping with scenario planning. The Daily Mail email came to us and I promptly forwarded it to you, Tara, and the team within minutes of receiving. Please give me a call and when you land so we can discuss and align on plan. Thank you. We received another inquiry and call when you land. Josh Greenston just contacted me. Jamie writes, Josh has asked to speak with you and I told him it was okay to call you. So while our position is the same regarding communications, this particular call with Josh, as it pertains to Wayfarer and Justin, you should take. Thanks. I am more than happy to speak to Josh. People Magazine reached out, but we have not responded. Let's get aligned on plan when you land. Where and when did that come in? And let's not respond at all. Not even an acknowledgement of receipt. Did not respond. 5:30 p.m. my time, but was at dinner, so we saw and texted you at 6:41. Is Melissa contacting Daily Mail or no? Then she puts out this, gives them the article of, the feud between them. Looks like this hit 3 hours ago, which is what likely prompted People Magazine to inquire with us. Nothing is from an insider, and all the quotes are attributed to the specific social media posts our team sent Jen Abel this morning at 8:11. And then somebody else comments, and that's redacted, chiming in here as the team knows this has been changing minute by the minute. What went from just monitoring and scenario planning as of yesterday escalated to Melissa and me having to have an off-the-record conversation with outlets such as the Today Show, since he was live today and they were planning on asking about the fan theories. New York Post has been digging since last week, since Justin hasn't been in any of the promo leading up to the junket, but via Melissa's relationship, they have been kept at bay with the assurance that we, along with Blake's teams, were not responding to any media. Unfortunately, Daily Mail has communicated to Sony that someone from Justin's camp has contacted them and provided comment, which has caused heat now with Blake's team. Steph, for full transparency, it was communicated to Sony by Daily Mail and also by Blake's team that it was you who called them and gave them info as Sony called us and told us this. The plan for now is to keep compiling the incoming request, which we are sharing as an FYI to Melissa's team, who are monitoring this for us while we continue to junket and have the screening tonight. And I have a call set later with Blake's team to smooth things over and ensure that her side isn't feeding anything else. And they know we aren't either. We have been giving the assurance that they also want this to die. Please let's share the inquiries from People Mag, as I don't have that one here with the team, and we will send to Melissa too. This is an all hands on deck scenario. Stephanie Jones. I didn't communicate with Daily Mail or anyone else for that matter. Daily Mail did not tell Sony I called them. 1, because I didn't, and 2, because a media outlet would never cite someone like that to another party. That's not how it works. Josh is aware of what's going on. Leslie Sloan maybe wrongly assumed this is coming from Justin's side, but the Daily Mail story is solely about the 3 social media posts that Henry sent you this morning at 8 o'clock. I wasn't aware that he had sent you those until Daily Mail inquired hours later. Let's align in comms and plan, as I need to be in the loop of media communications and plan. Please ensure I'm on those texts and emails. Thanks. Just communicated that we were told by Sony, and yes, we've been in lockstep with the social media team to flag in real time. The plan for now is just to forward all requests here and not respond. Jones. Leslie never communicated that to Sony. She's not listening to a damn thing they're saying. She's so hung up on not being the one to call instead. She, look at the texter. I mean, just wow. She says, Leslie never communicated that to Sony, nor did Daily Mail. Who at Sony told you this, Jen? What time? Oh, so I guess they redacted Jen Abel. This is Jen Abel talking. It's redacted, but she literally just said, who at Sony? Gosh, who at Sony told you this, Jen? What time is call with Leslie, as I would like to join, or I can shoot her a text now to coordinate call to ensure she is good and knows this isn't us. Jen Abel. Danny, who then was communicating with Josh and Gloria. Josh then texted me, accusing me of being the one who called Daily Mail as we were boarding. I straightened it out. There was no action needed. Jamie and the team are aware of all. Let's not do anything further, as when we land, we need to go straight into press and screening, meet and greet, etc. Jamie Heath chimes in. Chiming in for myself, he says, for clarity, I would like no one on our end to contact anyone until we have all talked. Thank you. Steph Jones. So Josh accused you first, which means my name wasn't given. Then Jen. No, Danny called me, then Josh texted me. Yes, and you noted that Josh accused you of talking to Daily Mail, which means my name wasn't given. It was given when Danny called me. I think it's odd as soon as our social team monitored and sent 3 TikToks that Daily Mail suddenly covered quotes from all 3 within the hour. No, Jen, Danny at Sony did not tell you that Daily Mail gave my name, nor did Josh. Josh assumed it was you per your text above. Jen is speaking with Danny and Leslie's team. My name is being cited. I do need to call Danny as well. Jen, what time? Oh my God, what a psycho. Jen, what time is call with Leslie, or should I contact her to schedule all of us getting on the phone? Jen replies, per Jamie, I am not contacting Leslie, and we are to stand down until we get through the events we have with Justin tonight. Jamie Heath, I'm confused right now. No one is to call Leslie. I don't know how to be any clearer. Why are my words not understood? I want us internally to speak first before anyone represents Wayfarer or Justin. Someone needs to tell me that they hear me. Jen, yes, copy. We are aligned. Tara Hanks, I hear you and we are aligned. Steph Jones, copied, aligned. Per Jen's above. It's kind of like telling someone like, sorry, but, Per Jen's above text, she proactively reached out to Leslie and team to smooth things over, so I assumed you approved that. Jen, please email Leslie's team to cancel the call you supposedly had. Also, please note that the New York Post sent no inquiries to you or our team last week or this week regarding Justin. I think she's really trying to throw Jen Abel under the bus because Jen Abel got Melissa Nathan. I mean, this just I would never want to talk with someone like this. Then she keeps going. Jillian at People Magazine following up again. I have a relationship with her, so I think I should reply. I'm on vacation in London with my entire family, but she can contact Jen. Aligned? Jamie Heath, Steph, please don't respond to any fashion. Even that you're out on vacation and then to direct to Jen, that is still a response of sorts. The position for now is to stay dark until further notice. Although you have a relationship with Jillian, as it pertains to this situation, there should be no response, no acknowledgement of the email itself. Thank you. Then she writes, cool, no problem. Then she likes the message and she says, I'll ignore. And then she sends them some attachments. And this attachment is from, it looks like it's from David, somebody. And he just writes, hi, Jennifer and Stephanie. We just read the Hollywood Reporter article covering the alleged rift between Justin and Blake while working on It Ends With Us and wanted to know if you have any comments to add. Let us know if you have a statement to provide, either on the record or off the record. Then she sends something else, and that's coming from E! News. They also want a statement, and that's where it ends. But holy moly, Stephanie Jones. Get the hint already. Don't talk to nobody, oh my gosh. But anyway, that's the entire thing. I don't know what to say about it. I think they made obviously very solid arguments. I think Stephanie motherfucking Jones's whole amendment is going to get dismissed. I don't know if it's going to go anywhere, but I can never tell when it comes to Judge Lyman. But the fact that they cited him 3 or 4 times, it definitely should. But that's everything you need to know in the Abel versus Jones case. That's what's happening right now. And yeah, check out my last video if you haven't. That's everything about the Isabel Ferrer and just some little nuggets in there as well. And I'll probably be going over the Jed Wallace and all of the PR stuff from the unsealing. Hope you're having the best Friday night. So awesome to be here with you. Thank you so much for your continued support. I love you, and I'll talk to you soon. Bye.